guys, thanks for stopping by. I wanted to give you a few pointers on what to expect in a temporary parenting plan hearing. Now, obviously, there's an action that's been filed and you're getting ready to have a hearing. You need to know what it's going to take to get your message across to the court. So, let's talk about that. The facts are the facts. So, we're going to go in there and you're going to tell the facts as you know them to be. You're not going to embellish them. You're not going to try and make up some story because it makes it sound better. No. All that's going to do is tank your case. What you want to do is tell the truth. Credibility in a custody action is absolutely paramount. So you have got to lay the foundation, do that from the time you walk in the courtroom. Be truthful so the court will know that you're being truthful. Be open and honest. Be concise in your statements, but be honest about what you're telling the judge. You don't want to get caught in a lie. That's the worst thing that can happen, especially in a custody case. It could cost you your children. That's not what you want. So the financial information, if you watch the other videos on temporary hearings, that financial information would all be relevant and appropriate as we go forward with a temporary parenting plan hearing. Again, a temporary hearing is just that. It's a temporary hearing. The court's in my jurisdiction, and I practice in Middle Tennessee. We expect that those are going to be the Band-Aids that take us all the way to the end of a case. It sort of sets the tone for what we expect. On the other hand, if something happens in the middle of our case, we can come back and ask the court to change it. But you need to know it's not likely to happen. You have to know your income when you go in on a temporary parenting plan because we have to set child support. In the state of Tennessee, child support's mandatory. It's a requirement based upon the guidelines. It's driven by a day count, which is critical when you're trying to figure out where the kids are going to stay, how they're going to spend their time, and who's going to pay for it. So if you've been separated for a while, or even if you haven't been separated for very long, but know the date, know when you separated. The reason you need to know that date is we calculate child support back to that date. Now, if it's been 10 years, the court, obviously has the discretion to go back that far, but it's not likely. So, if it's been 6 months or if it's been 3 months, you just need to know your dates. So take a minute, look over your journal, figure out what those dates are, and remember them. Know whether or not your spouse or your partner has paid support. Know whether or not they've paid the bills, whether or not they've paid the child support, whether or not they've helped you with daycare or with other financial needs that you may have needed for the children. Who's paying the health insurance? How much is the health insurance? That's all information you're going to need for a temporary hearing on a parenting schedule. How long have you been sharing the children? What kind of schedule have you kept with the children? Who is the one that dictates the schedule for the children? So if you have one parent who's overly controlling and has refused the other parent to be seeing the children because there is no court order, that's a fact that your attorney needs to know. That is a relevant fact when it comes to a parenting plan schedule, and it is something that needs to come out in this hearing. So you need to have that information and have shared that information with your attorney. Be concise, be accurate, be as simple as you can be with your answers. You have to answer the question again, yes or no, and then small answers for justifications for that. If you get asked on the witness stand, if you have a certain day schedule or parenting schedule that you're proposing, you have to be able to explain to the court why you think that schedule is in the best interest of your children. So if, for example, you work third shift, how are you going to be able to make do being the primary residential parent? Who's going to take care of the kids at night while you're working? If you have always been the primary residential parent and that was okay with your other significant other, then you need to be able to explain that to the court. But if you are a stay-at-home mom or stay-at-home dad and you've been the primary caregiver while the other person has been the night shift worker, you need to be able to explain that too. If you have asked your attorney to file a petition and ask or propose a parenting plan that requires supervised visitation, you need to think long and hard about that. Because the truth is, you have to justify that to the court. You have to explain to the court why that's appropriate. You will need to let them know what's going on in that other parent's life that is so bad that they need to be supervised with their children. So if that's an issue of drug abuse, we have to be clear about that. If that's an issue of a lack of parenting, you have to be clear about that. I'm sure that you have a journal. You'll need to refer to that journal and have that information easily recalled so that you can give that to the judge whenever the question is asked. If you have that kind of journal, it's going to bolster your case. It's going to help you prepare. If you have a list of those things, you need to provide that list to your attorney so that your attorney is well prepared going into the hearing. It's a partnership when we do these hearings. It is so important that the client is engaged and that the client you're the one that knows these facts. So if you have prepared an itemized list and say, here, Mr. Attorney, Miss Attorney, these are the things that have gone on, then it is so important for that attorney to take that information and get it before the judge. So many times in these cases, it becomes an emotional overload. And so it becomes difficult to fight through the weeds and figure out where the truth lies. But you're the one walking this stuff. You're walking it on a daily basis. The attorney that you're working with, sure, they're guiding you. I'm guiding my clients. But I'm not living what they're living. So I ask my clients to prepare an itemized list. I ask that you tell me on January 19th of 2021, this is what happened. Why did he act this way? Why did he do this? Those are the ways that you can help your attorney and ultimately help yourself, because you have done everything that you can do to be proactive and help your attorney get prepared for court. If you're asking for supervision, you got to know why you're asking for supervision. If you are asking for supervision, I don't know about all states, but the state of Tennessee, we don't have a supervising agency that the state funds for supervision. So in my jurisdiction especially, if somebody's asking for supervised visitation, well, they're probably going to have to pay for it, or at least bear some of the burden of the cost of a supervisor to go and do the supervision. The one thing that you got to remember is when you're talking about your children, always refer to your children as our children. Don't refer to the kids as my kids. That's hurtful. You don't want to present that as a one-sided type parent to the court system. It does not serve you well, or at least it doesn't in my jurisdiction. If DCS has been involved, your attorney needs to know that. It may be helpful, it may be hurtful, whatever, but they need to know. The other thing that you got to know is don't use your kids as a weapon. If your kid says, Mommy, I miss Daddy and I love Daddy, and why can't y'all be together anymore? You need to assure your child that you love that child, that Mommy and Daddy just have differences and the adults have to work things out. But the hatred and the back and forth, running the tails between the children and the parent, it's not beneficial to your children, and at the end of the day, you're going to be the one to pay the price. I hope that this has been helpful. I hope that you got something from it, and I'll see you guys in court.